Regarding the duty of measures to be taken on dangerous articles, a person who is bringing on board as offensive weapon, explosive or inflammable article, toxic article specified in the Management Act for noxious chemicals or any other dangerous articles shall make a declaration of the possession immediately to the master. This is stated in paragraph 1, and the master may take necessary measures such as surrendering or abolishing on the articles specified in paragraph 1. The master may take necessary measures on the behavior of crew or other person on board to prevent a hazard to the vessel when they commit an act which may be harmful or dangerous to life or to the vessel. Regarding master's request of assistance to the administrative agency when a seafarer or any other person on board does harm to human lives or ship or seriously disturb order on board a ship, the master may request the head of a related administrative agency to give aid to him or her as necessary to maintain order on the ship. The chief of the administrative agency in port shall cooperate with the master for the request pursuant to the provision of paragraph 1. The same notion is stated under the clause. Regarding restriction on action in labor dispute, a seafarer is not allowed to cause strife on a seafarer's labor relation in cases falling under one of the following sub-paragraphs. First, the ship is in a foreign port. Second, passenger ship with passengers on board is at sea. Third, a specialized ship to carry dangerous cargoes is at sea. This specialized ship means tankers and any other ships carrying dangerous goods. Fourth, a ship is at sea with the master being in direct command in accordance with the provision of the Article 9. Fifth, the fishing vessel is under fishing operation during which fishing gear is lowered and heaved up and until refrigeration is completed at fishing ground. Or, last but not least, other cases that give rise concern of a remarkable hazard to a life or to the vessel due to labor strife on seafarers' labor relation. Next slide. With respect to prohibition of forced labor, a ship and a seafarer shall not enforce a seafarer to work against his or her own free will through the use of violence, intimidation, confinement, or any other means by which the mental or physical freedom of the seafarers might be unduly restricted. As you may have noticed, a seafarer can also become a perpetrator of principle of prohibition of forced labor if he or she breaches the law. Chapter 4 sets out the provision relating to seafarers' employment contract. Firstly, Article 26, which is about contract in violation of this Act. This article sets out that where a seafarer's employment agreement stipulates the working conditions that fails to meet the standards prescribed by this Act, only such part shall become null and void. In such cases, such null and void parts shall conform to the standard prescribed by this Act. This is what we call partial null and void principle in labor law. Secondly, regarding clear statement of working conditions, where a ship owner enters into a seafarer's employment argument, he or she shall make wages, hours of work, and other labor conditions specifically clear to a seafarers. The same shall also apply where he or she changes a seafarer's employment agreement. When a ship owner enters into seafarer's employment agreement with a seafarer, where the seafarer's wishes, the ship owner shall provide opportunity that the seafarer may review the details of seafarer's employment agreement and be provided with advice and suggestions about the same. The same shall also apply where the ship owner changes a seafarer's employment agreement. The obligation of a clear statement of working conditions was introduced in order to implement the MLC 2006 as amended. Regarding limitation to rescission of the seafarer's employment contract, firstly, the ship owner shall not make a rescission of the seafarer's employment contract during the period of below. The period of seafarer's absence from the job due to an occupational injury or medical treatment of sickness and over 30 days after completion of this period. Or the period of a seafarer's absence from the job due to a maternity leave for a woman crew member who is before and after childbirth, pursuant to the provision of Article 84 of this Act, and of 30 days after completion of this period. However, this regulation shall not apply to the cases that the ship owner cannot carry out his or her business due to an act of God or any other unavoidable reasons subject to the recognition of Seafarers Labor Committee, or that the ship owner has paid a lump sum compensation to the seafarers pursuant to the provision of Article 98 of this Act. Relating to the obligation of advance notice of rescission of the seafarer's employment contract, if the ship owner wishes to make a rescission of the seafarer's employment contract, first, he or she must make a written advance notice of rescission to the seafarers more than 30 days prior to the rescission of the contract. Second, if the ship owner fails to give this advance notice to the seafarer, he shall pay an amount of money equivalent to the ordinary wages of 30 days or more to the seafarers. This is sort of a penalty. However, this regulation shall not apply to any of the following cases. First, where the ship owner cannot carry on his or her business due to an act of God, or sinking or loss of vessel, or any other unavoidable reasons subject to the recognition of such fact by the Seafarers Labor Committee. Second, where the seafarers left the vessel without a justifiable reason, or third, where a seafarer is submitted to disciplinary measures of being forced relieved from the ship pursuant to Article 22, Para 3. Where a seafarer intends to rescind a seafarer's employment agreement, he or she shall inform a ship owner of his or her intention with a period of advance notice of less than 30 days, as stipulated in a collective bargaining agreement, the rules of employment, or the seafarer's employment agreement. Regarding continuity of the seafarer's employment contract, firstly, where a seafarer's employment agreement is terminated while a ship is out at sea, such a contract shall be deemed to continue until the ship enters the next port and unloads all cargoes to be unloaded, or lands all passengers who are to leave the ship at that port. Secondly, when the ship owner's employment contract is to terminate at a port where the embarkation and disembarkation of the relief seafarers is not proper, the ship owner may keep the contract in effect until the completion of unloading all cargoes or completion of landing all passengers after entering a proper port for the relief within the period of not exceeding 30 days. This special provision is reflected to ensure the safety and continual operation of the vessel concerned. Turning now to special cases for termination of the seafarer's employment contract. Except for cases by general succession, such as succession, etc., where a ship owner is changed, a seafarer's employment agreement made with former ship owner shall be terminated. And from then on, first, a new seafarer's employment agreement by and between the new ship owner and the seafarers under conditions the same as those of the former seafarer's employment agreement shall be deemed to have been made. Second, provided, however, that a new ship owner or seafarer may cancel a seafarer's employment agreement by informing the cancellation thereof in writing with a period of advance notice of not less than 72 hours. Therefore, when a ship is sold out to another ship owner to which Korean Seafarers Act is applicable, then the existing SAA terminates and a new SAA deemed to be concluded between seafarers on board and the new ship owner. This is a very, very special provision. However, if a seafarer wants to cancel the new SAA, then he or she can cancel it in writing with a period of advance notice of not less than 72 hours. This slide shows special cases for termination of the SEC as set out in Article 36, except for cases by general succession, such as succession, etc. When a ship owner is changed, a seafarer's employment agreement made with former ship owner shall be terminated, and from then on, a new seafarer's employment agreement by and between the new ship owner and the seafarers on the condition same as those of the former seafarer's employment agreement shall be deemed to have been made, provided, however, that the new ship owner or seafarer may cancel a seafarer's employment agreement by informing the cancellation thereof in writing with a period of advance notice of not less than 72 hours. If you do not actually notice such advance notice, then you cannot actually cancel that contract. Regarding termination of seafarer's employment contract, there are two categories of termination. First category is a sort of general reasons which can be applied to every employment contract, including shore workers. Namely, firstly, cancellation or rescission of contract by either party. Second, termination due to completion of contract period. Third, death of seafarers or workers. Fourth, completion of business concerned. Fifth, retirement of worker. Sixth, completion of suspension from office. Seventh, inability of workers to work. Eighth, termination due to bankruptcy of the employer. Second category is a sort of special reasons which can be applied to the following cases. Firstly, termination when a ship was sold. Secondly, termination when a ship was donated. So these two cases are specially stipulated in Seafarers Act. What do you mean by justifiable reasons? Key example of justifiable reasons held by Korean court cannot be categorized as follows. As we talked about the previous slide, you cannot actually dismiss any workers without any justifiable reason. But Act itself doesn't mention anything about what are the justifiable reasons. Therefore, that justifiable reason need to be determined by the court. Therefore, the following are the justifiable reasons held by the Korean court. Category 1 is sort of workers' personal causes, namely retirement ages. Then you can dismiss. Secondly, disqualification, inability to work. Thirdly, alcoholic drug abuse. Second category is related to workers' behavioral causes, namely denial of working, grave negligence of duty. Secondly, absence without permission or frequent lateness. Thirdly, drinking alcohol on duty. Fourthly, contempt of ship owner or senior workers. Fifthly, disobedience to job order of ship owner or senior workers. Sixth, violation of code of practices on industrial safety, health, and hygiene. Seventh, violation of safe working practices. Eighth, disclosure of business confidential matters. Ninth, receiving bribery. 10th, operation of competitor's company. 11, non-occupational misconduct or criminal offense of work. Therefore, a seafarer cannot be dismissed without a justified reasons, as highlighted above, whereby employment stability can be secured within the period of a seafarer's employment agreement. Regarding ship owners' obligation of repatriation, firstly, where a seafarer leaves a ship at a port which is not the place of his or her residence, or a place where he or she concluded a seafarer's employment agreement, a ship owner shall repatriate him or her to a place where he or she wishes to be repatriated, either a place of his or her residence or a place where he or she concluded the seafarer's employment agreement without delay at the cost of ship owner and on his or her own responsibility, provided, however, that this shall not apply where the ship owner reimburses expenses incurred in the repatriation at the request of the seafarers concerned. The expenses of repatriation shall include transportation, accommodation, and meals, expenses incurred in the repatriation, and other expenses prescribed by the enforcement ordinance. These other expenses usually include medical care cost. A ship owner shall pay the seafarers an amount of money equivalent to his or her ordinary wages as a repatriation allowance according to the number of days required for repatriation. The same shall also apply where the ship owner reimburses the expenses for repatriation. Notwithstanding paragraph 1 above in the previous slide, the ship owner is entitled to reimburse the repatriation expenses from the seafarers and do not need to pay repatriation allowance in the case of the following. First, where a seafarer leaves a ship at his or her discretion without a justifiable reason. Second, where a seafarer leaves a ship after he or she has been disciplined by being made to leave the ship pursuant to Article 22, Para 3. Third, where a seafarer falls under the region prescribed by a collective agreement, the rules of employment or seafarer's employment agreement. However, the ship owner shall not claim an amount of money equivalent to 50% of the expenses incurred in the repatriation of a seafarer repatriated after his or her has worked on board for 6 months or more. A ship owner of ocean-going vessels shall take out insurance or becoming a member of mutual aid, which means the P&I club, in order to repatriate a seafarer to the place of his or her residence or a place where the ship owner concluded SEA with him or her. Regarding measures for repatriation of seafarers, where a seafarer requests the Minister of Oceans and Fisheries to repatriate him or her because of a ship owner fails to perform his or her duty to repatriate him or her under the Article 38, the Minister shall repatriate the seafarers. In such cases, the Minister may claim compensation for the expenses incurred in the repatriation against the ship owner. Where a foreign seafarer who goes on board a foreign ship's requests the Minister of Oceans and Fisheries to repatriate he or her, then to his or her country because he or she is deserted in the Republic of Korea. Deserted means abandoned in Korea. The Minister may repatriate the relevant seafarers to his or her country. In such cases, the Minister may claim compensation for the expenses incurred in the repatriation against the flag state of the relevant foreign flag ships. The Minister of Oceans and Fisheries shall not charge the expenses incurred in taking measures for repatriation under paragraphs 1 or 2 to the seafarers, which means that seafarers shouldn't be requested to bear any cost. The Minister of Oceans and Fisheries may give an order to detain the relevant ship until the expenses incurred in the measures for repatriation under paragraphs 1 or 2 are reimbursed. These provisions were introduced in order to implement the relevant requirement under the Maritime Labor Convention 2006 as amended. In relation to the ship owner's obligation for providing financial security for the abandonment of seafarers, the ship owner of a ship taking international voyages shall provide a financial security system for the abandoned seafarers caused by any one of the following. Firstly, where a ship owner does not repatriate or does not cover the cost of repatriation. Second, where a ship owner does not pay 2 months or more of wages or sever ties with seafarers on board. Or third, where a ship owner does not provide food, drinking water, essential fuel, and medical care, etc., necessary with the seafarers. This was introduced in order to implement relevant requirement under the Maritime Labor Convention as amended. Chapter 5 contains various provisions about wages. With respect to the payment of wages, a ship owner shall pay wages in full in currency directly to a seafarer, provided, however, that where there are special provisions in the Act and subordinate statutes or collective agreement, he or she may deduct part of wages or pay wages by means other than currency. The ship owner shall pay wages on a regular fixed date on less than once a month, provided, however, that this shall not apply to payment prescribed by the presidential decree, such as wages paid temporarily, an allowance, any other corresponding thereto. Notwithstanding paragraph 1, where a seafarer requests or there are special provisions in Act and subordinate statutes or a collective agreement, a seafarer shall pay all or some of the wages to his or her family or any other person designated by him or her in currency or by means of deposit with a financial company, etc. Notwithstanding paragraph 1, where a seafarer working on board requests a ship owner shall have a master pay some of the wages to a seafarer directly in currency in common use in the port of call. This is because seafarers need to spend some of the money in port when they go out shore leave. Regarding wages of seafarers in the service of the ship during injury or illness, even if a seafarer working on board is unable to perform his or her duties due to injury or illness during a period he or she is in service of the ship, a ship owner shall pay such wages as if he or she performs his or her duties to a seafarer other than fishers, and pay ordinary wages to fishers. This means that the seafarers on merchant vessel shall be paid in full, but fishers, they will be paid in ordinary wages. Provided, however, that this shall not apply where Seafarers' Labor Relations Commission deemed such an injury or illness to be caused by his or her intention. So this is the exceptional case. Regarding insurance, the warranty insurance for wage claim, etc., the ship owner or the Korea Shipping Association shall take out an insurance, join the mutual aids, or raise a fund to provide a warranty for payment of the following outstanding wages. First, the amount of latest 4 months of wages. Second, amount of latest 4 years of retirement allowances, notwithstanding Article 469 of the Civil Act, where a retired seafarer claims outstanding wages, an insurer, mutual aid, or operator of funds under the paragraph 1 shall pay outstanding wages in lieu of a ship owner. An insurer, mutual aid, or operator of fund who has paid outstanding wages to a seafarer pursuant to paragraph 3 shall subrogate a claim for wages in arrear of seafarers against relevant ship owners within the limits of the amount of money paid to seafarers. This was introduced to implement First Amendment of the MLC 2006 as amended in relation to outstanding wages and entitlements. Chapter 6 prescribes about manning, which is a public law in nature. Regarding the embarkation of a competent seafarer, the ship owner shall embark 3 ratings or more for navigational watch in the deck department on the vessel of 500 GT or more, of which sailing hours is 16 hours or more in a day. A ship owner shall embark competent seafarers qualified on the vessel carrying dangerous cargoes. The ship owner shall embark qualified lifeboatsmen as appropriate. First, a lifeboat for 40 persons or less needs to carry 2 lifeboatsmen. Second, a lifeboats for 41 to 61 persons need to carry 3 lifeboat persons. Third, a lifeboat of 62 to 85 persons need to carry 4 lifeboat persons. lifeboats for 85 or more persons need to carry 5 lifeboats per person. Fifth, a rescue boat or fast rescue boat needed to carry 2 lifeboats per person. Sixth, life rafts need to carry 1 lifeboat person. In relation to general manning, the ship owner shall obtain an approval from the Maritime Authority for the required fixed number of seafarers on a vessel. The Maritime Authority shall issue a manning certificate, what we call self-manning documents. The ship owner shall embark the required number of seafarers and recruit seafarers immediately if there is a vacancy. Regarding reserve seafarers, the ship owner shall secure reserve seafarers equivalent to the number of 10% of total seafarers on board or more. Ship owner shall pay 70% of ordinary wages as wages to the reserve seafarers other than those on paid leave, etc. Chapter 7 prescribes provision on food, safety, and hygiene on board, which is a public law in nature. In relation to ship owners' obligation for providing meals on ships, first, a ship owner shall supply seafarers on board with food and water of a proper quantity and quality, provides equipment necessary for cooking and providing meals, and provide the meals on a ship. In such cases, he or she shall consider various cultural and religious backgrounds of seafarers working on board. Ship owner shall also provide adequate quantity and quality of foodstuff and water for the seafarers on board, and supply a provision of food with the necessary arrangement and equipment for cooking. Second, a ship owner shall have a cook on a ship who has qualifications to provide meals on the ship, provided, however, that the ship prescribed by the presidential decree may be exempted herefrom, or a ship owner may have a person who have a knowledge of and experience in cooking and providing meals on a ship work on board in lieu of the ship's cook. Last but not least, the Minister of Oceans and Fisheries shall conduct examination and an examination for qualification for a cook on a ship as prescribed by the presidential decree, which means that in order to become ship's cook, you need to take a compulsory education and you need to get the certificate from the minister. Regarding the cost of provision of food on board, in lieu of supply of foodstuff, a ship owner may disburse expenses incurred in purchase of foodstuff to provide meals on a ship to the master, and have him or her manage the provision of meals on a ship with approval, therefore, from the minister. In such cases, the master shall manage so that meals are provided to all seafarers on the ship without discrimination regardless of nationality, sex, etc., etc., etc. When the cost of the food is paid, the standard amount of money per one person in a day shall be clearly specified. Minister may fix the minimum standard amount of cost for providing meals on a ship. In such cases, ship owner shall disburse cost for providing meals on a ship more than the minimum standard amount. The cost of food shall not be paid for any expenses other than the cost of food on board and the cost of transportation of the food. Regarding safety and hygiene, the ship owner shall comply with the provisions for the maintenance of working tools, providing medicines, executing education on the safety and hygiene, and for other requirements concerned with the prevention of danger on the ship and maintenance of hygiene on board. Second, the ship owner shall employ proper seafarers with an adequate exercise or skill for the dangerous work on the vessel. Third, the ship owner shall not embark any seafarers who has an infectious disease, mental disease, or affected with other diseases as set out by the ordinance, which means that only persons who has medical fitness can embark on board. Fourth, a ship owner shall provide seafarers with protective equipment and protective devices, etc., and prohibit them from using machinery without a protective device. Fifth, when an occupational accident, etc., of a seafarer occurs, a ship owner shall immediately report such fact to the competent authorities of oceans and fisheries. Sixth, the seafarer shall comply with the regulations prescribed in the ordinance for the prevention of danger on the job and the maintenance of hygiene on board. Seventh, a seafarer may refuse the use of a machine that has no protective equipment or does not operate properly. Last but not least, the master shall not reject without a just cause the seafarer's request of medical treatment for his sickness and injury by a medical facility at a port of call of the vessel. In relation to the investigation of occupational accident, first, upon receipt of a report on the fact of the occurrence of an occupational accident, etc., the minister shall investigate the fact and causes thereof. Second, to prevent occupational accident, etc., from occurring, the minister shall maintain and manage statistics regarding occupational accident, etc., investigated pursuant to paragraph 1 above, and may analyze such statistics and publish an information package. Last, matters necessary for procedures of the details of an investigation or disposal of the result of an investigation under paragraph 1 shall be prescribed by the enforcement ordinance of the Minister of Oceans and Fisheries.